In 1903, they've deleted the existing VEQ clause, but they partially restored it, but as Christine explained, only for things that are significant, meaning that it's got to be a value greater than 5% of the existing contract. They'll pay on force account. Force account records have to be signed daily by MnDOT, otherwise yours won't be valid. And their records control over yours. Fortunately, they were initially going to require that you prove any inefficiency claim by what's known as a measured mile approach. But sometimes it's impossible to find a mile that's a significant baseline or accurate baseline from which to compare all other miles on your project. So now you can use any other reasonable method. If it's, again, confusing to me, if they're willing to be reasonable on something like that and not specify the exact method by which to calculate a claim, why are they so stubborn about specifying the exact schedule? Don't know. Lost profits now, non-allowable charges, lost profits, that's typical, but consequential damages they are now excluding. That can be loss of bonding capacity, indirect costs. They're even excluding the cost of litigation. Now those are routinely allowed by a court. In fact, a court has authority to assess the cost of litigation against the losing party, but MnDOT is attempting to exempt itself from either that. That is a change in the law. At our request, they have allowed extended unabsorbed home office overhead. The ICLAI formula is now able to be used on the limited conditions that it can be. Interestingly enough, they say subs can now use the ICLAI formula unless a general contractor has inserted a subcontract clause disallowing it. It's questionable whether such a subcontract clause would be valid given the statutory prohibition against no damages for delay clauses. But MnDOT apparently used that clause to some success in a claim, and they want to preserve that success in their standard specs. Christine pointed out earlier that MnDOT can withhold payments from any other contract if there are charges it wants to assess on this contract. That will cause a cascading effect on other bonded jobs. If you don't get paid on other bonded jobs, claimants will make payment bond claims on those jobs, and on it will go. This is a troubling provision. Remember when I was discussing False Claims Act liability, I said a payment application is a claim, and when you certify a pay application, you're certifying that you're complying with all aspects of the contract. Here's the provision that says that. You're going to state that everything you've done meets the requirements of the contract, and that's what subjects you to the False Claims Act here. And finally, cost escalation. Many of those provisions have been deleted from the standard spec, but MnDOT assures us they'll be reinserted in special provisions such as the fuel escalation clause. Now, I know this has been a race through all these specifications, and what we've done is just listed what we think are the major provisions that shift contract liability. There's all sorts of changes just on how you need to manage the job and what MnDOT expects from you that it unfortunately will require a read from start to finish of Division 1. So, but it's important to know these things, and Christine and I are going to put together a shorter template that might be able to be used by superintendents and project managers to keep track of some of these important dates, just to have a handy reference in the field, because it's tough to know this. I was telling someone over the break, just when we've learned the chapter and verses by heart, they've changed the chapter and verses on us, and now we're going to have to go back to school and learn them again. But that happens from time to time, and that's what we have to do. So, we're on time. I've got time for a few questions before we bring up our august panel. Yeah?
Are you saying on pay applications that we should put on there, get a rubber stamp or something that says to the best of our knowledge? What did you say?
Well, you have to certify that your pay application complies with the contract. When you're saying something to MnDOT, you're sending a letter to MnDOT or a document to MnDOT that this is to the best of our knowledge, the best of our reasonable knowledge. Because according to MnDOT's definition of a false claim, if your document or your statement happens to be false, it subjects you to false claim liability, even though it doesn't relate to a claim for payment. That's the problem. And if that's not clear, I don't blame you for it not being clear, but that's what MnDOT is trying to do. It's just trying to create liability for anything that it thinks is false, and that's not what the False Claims Act says. Yeah.
In that shutdown deal, we got stuff from subcontractors, tried to tender that business to the general prime contractor. Anything we got from the sub, we just, tendered it on, that we would have to back that statement up with their stuff. I don't know if that ever got resolved with that. We always put that statement on the best of our ability. Do you see that where that would even be where a prime would be responsible for stuff coming from the sub, where it's all innocent, against equal up or not?
Yeah, it's a great question. I'll summarize it. Can general contractors be stuck under the False Claims Act for passing through a claim from a subcontractor? And if the subcontractor claims turns out to be false, is the general liable under the False Claims Act? I think there's a significant risk that yes, you are. That in fact, MnDOT wants you to certify that your subcontractor's claim is true and accurate and go through all the claims procedures that Christine outlined. I think the best way to deal with that, Butch, would be to address it in your subcontract. That your subcontractor, in submitting the claim upstream to you, agrees to be bound by the False Claims Act and agrees to certify its claim so that you can rely on it and would hold you harmless to the extent that it's not. That's what's done in any number of other industries, and we've had a cooperative industry thus far that we haven't needed to do that. But now that MnDOT is imposing that type of risk and threat against you, I think that's something that's just prudent to do. Dennis.
With that in mind, if the subcontractor certifies it with MnDOT's language, the general is afforded limited availability of those documents. We don't have an open book for our subcontractors' records. So what if MnDOT does find something wrong? We have our subcontractors certify it, and then we just say, well, to the best of our knowledge, just what you said. What is our liability then?
It's almost like the duty to investigate cuff. You can't rely on the fact that the DBE has been certified. You just can't rely on the fact that your subcontractor has signed the same claims form that MnDOT will request of you. If you don't have the contractual ability to investigate and test your subcontractor's claim, you really ought to change your subcontracts so that you do. I've had lots of general contractors who have frankly refused to pass a claim upstream because the subcontractor's claim just didn't seem right. And in fact, when we looked into it, it wasn't right. I mean, look, there's all sorts of things that you need to shake out of a claim to avoid a False Claim Act assertion. And so you ought to insist in your subcontract that you can audit a claim before it is passed on through you. Just like you would audit your own claim before you submitted it to MnDOT, which is something you ought to do. Yes?
Recently went through a reconsideration hearing. Win or lose, I wanted to get out of it. What does the state view as a reasonable or not unreasonable premium to pay for a higher DBE quote? I thought I got that 5% would be a reasonable premium for the client to expect to pay. But I couldn't get any more than that. Did you have any success?
They intentionally will not say. And they've said that they will intentionally not say. So this is no surprise. They don't want to say because they say it changes from case to case. If bids turned out to be very tight, maybe they'll find that a 5% premium is okay. If the bids after the fact turned out not to be very tight, unfortunately they will hold you to a higher percentage. And they'll say, well, you could have paid a lot more than 5% and still got the job. Well, true enough, but how did I know that when I was bidding the job? So that's why it's this after the fact analysis of what's reasonable that is vague and ambiguous. But that's life. I've heard 5 to 7% as well, but in the reconsideration hearings in which I've been party to, they've always questioned why we just didn't do more than that. Greg.
Also, pipe in, if they're substantially higher, I had one where the lowest DB quote was 25% higher. The response was, well, did you assist the DBE in getting his bid down? Did you tell him what the other bids were? We say, we can't do that because no subs were told. We say, well, you've got an obligation to help them and assist them, so you've got to do whatever it takes if their bid is out of line to get it down where it should be. So it's one of those damned if you do and damned if you don't. I mean, if they want to find something wrong with your DBE submittals, they will.
Yeah. Yes.
As part of 1800, did they retain in their modification of it that all of those schedules, regardless of what type they are, have to be developed and maintained in their server system? Or is that gone?
Well, I mean, you do have to send them an electronic version that is capable of being used by them, I think, in Primavera. So, yeah.
They changed it in the latest spec. Now you have to do your schedule on their server.
Oh, really?
You're not allowed to have your own, and they
Can't
send
upload
it
it.
to them.
Huh.
They will
So,
not accept a file import.
so you can't put a virus in your schedule anymore and send it to them?
But the problem we're finding is that they don't try and, it comes part and parcel to trying to get the baseline approved for a client in that they don't have the space or the quote seeds column, whatever you will, for anybody to get onto their system so that you can't, and because you have to develop it on their system, you're catch-22 to the nth degree. Is that something that, you're saying you can't even develop this on your own business operation? Is that new methods as well?
Well, that's why I hope we can have a continuing discussion with them so that it works not just for them but for the industry as well. I'm all for making life convenient for the consultants, but maybe not that convenient.